is a pretty good drop-off to the other side of the driveway. There are two culverts that go under the driveway. One that more or less drains from the applicant's property, and the other one more on the butter's property and other properties that are a little bit further uphill. The nature of where the garage is going to be located versus the delineated wetland, there's no filling of wetlands, it's just the buffer area, so there should be no change in the amount of water that's going into this particular wetland. As the applicant mentioned, they have been before the Conservation Commission. There were no additional conditions imposed by the Conservation Commission. They meet all the site plan regulations, providing they get the approval of the CUP, of course. Staff recommends the board grant the conditional approval with the following criteria for the finding of fact. They're encroaching into the wetland buffer, not into the wetland. Conservation Commission has agreed with that plan. And they will have to include erosion controls when they get to construction, which they have agreed to, and they understand the need for a driveway permit if they do an extension of the actual driveway.
Thank you. Any questions for staff? Rob?
Dean, did you find an answer to my question that I had posed to you earlier last week about whether that driveway or right-of-way that is adjacent to the lot is a road, and that would be a front setback, that driveway would be, that garage would be on?
It is not a road, it is a right-of-way for the property behind, for their driveway. It services one lot. All the other lots have road frontage on another lot, another road, sorry.
So is that in the NOA from that approval for that subdivision, that was a driveway?
We don't have that. But I did find the plan in the archive room, and it is for right-of-way for the driveway to the rear lot.
Okay, I just don't want that to come back later on and somebody say that should have been a front setback and that didn't meet setback requirements.
If it was a Class 6 road, it would be, right? But it's not. It's a private right-of-way? Is that what I'm hearing?
Well, I think that there's there might be plausibly something that said that if there was so many lots that utilized,
Oh, right.
that would then become a road. And I was
I
concerned
call it
that,
more like a shared driveway in this case.
well, you're allowed to have a shared driveway, but what if you hit 3 or more lots, then it becomes a road. So that's what I was trying to make sure that we were protecting, and that,
Gotcha.
that didn't become a front setback.
Good thinking.
Obviously, the applicant's lot, property
Notice that.
is on Woodward Hills Drive. The first property in is also on Woodward Hills Drive. Across the right-of-way is a piece of property that about a year and a half ago did a boundary line adjustment so that they got frontage on Watson Road. I don't know if you remember that one.
I do remember that one.
So they, in theory, could use this right-of-way, but they don't need it for frontage
lot
or anything like that. So the only lot that is using this right-of-way, and they're using it for their one driveway, is the lot to the rear.
Okay, one more question, if you don't mind. That wetland didn't meet the size requirement to be exempt from the CUP requirement?
No, it's just
No, it was
over,
5,000 or
Oh, it's
something.
5,000? Just
5,000.
over, huh?
well,
I had-
60%
I had
over.
I had three different people measure it, and first it came out 3,000, we went through this whole thing, and then it came out 3,200, and I'm like, wait a minute, I gotta get more accurate. So I brought in the wetland scientist again, redid it all, and he gave me an actual 5,200, so it unfortunately was higher than, we went through it a ton of times, so yes.
Mr. Gallo?
I don't see anything on the plans, and I guess probably the Conservation Commission would have addressed it, gravel drip edge around the side of it,
Yes,
because you are increasing the impervious direct,
Correct. There was two
Neighboring the
discussions. We always put gutters on too, and the gutters go right in the perimeter drains.
Okay.
And so we do that automatically, and in addition, I always put stone around, because I don't like splash up.
Yep,
So I think
okay.
we had a chat in conservation about that, and that's
Okay.
probably why they didn't put it on.
yeah,
So,
I just didn't see a note. All right, great.
Awesome. Any further questions for anybody about anything?
Could we add those, if that's what he was doing anyways, just add those as conditions of approval, just to safeguard and to
So it's on record.
codify the mitigation of the
Can,
drainage?
Sure, you can make the
could do
motion.
that, or we can just, we'll
Write it
make a
down.
note of it on the building permit.
Yeah.
Either way.
Because the building inspector will look at it if you want to do that. Either way, it doesn't matter, but I do it anyway, so.
Mr. Moore has agreed to deal, to word the motion, so. Yes, Stacy?
One last comment. I know you had said silt fence. Conservation does prefer silt sock, just to let you know.
Okay, sure.
For,
Yeah, the tubes, yeah. We've used either way, because I do pretty much lakefront. Most of the stuff I do is lakefront. So we used to do silk fence with hay bales behind it and no sock in, but if you
Right.
prefer a silk sock, that's
they
fine.
just seem to be getting a lot of
Okay.
complaints from residents
That
that
the
the
silt
fences
fence are
weren't
failing.
working. Yeah, so
Perfect.
they switched over and they try and encourage a silt sock.
Perfect, yeah, it's a small area, so I can easily run over there, absolutely. Good
Perfect.
point, yeah, sure.
Those are biodegradable too, aren't they?
Yeah.
Are they really?
Yeah.
No kidding, huh?
Yeah,
You
just
just leave them in and let them go?
So if you leave old
Wow.
pantyhose full of wood chips
Wow,
out
isn't
there,
that something?
biodegradable.
I'll
True
leave that
fact,
one alone.
true
That's
fact.
right, right.
Anywho.
It's amazing what you learn at these meetings.
That's only for V-shaped lots. Okay. Sorry. Any other questions?
Wow, this planning board meeting's on fire tonight.
We're not going to jail with you.
What about that, Steve?
I want you to know.
Yeah.
Sorry? Sorry? Momentary lapse of civility there. Anyway,
This is why you are chair.
no, this is not. But anyway. Any other questions, comments? All right, sensing none. Mr. Moore, do you have a motion?
Do you have any findings of, do we do any fact finding for this one?
I think you could find a number of things.
Findings.
Staff
Down there
report.
towards the bottom of the page.
Yeah, conditional use permit, if you read that, permit requirements is a,
Conservation Commission has signed off on it.
So I guess we could do fact finding that the Conservation Commission reviewed that and they didn't take any issue with the proposal. The applicant is gonna make, gonna have some mitigating, strategies in construction,
the garage is gonna have no sewer, no water,
sewer, no water.
no heat, no living quarters.
I would
It
suggest
will have
a,
heat. It will have heat.
Oh, it'll have
Yeah,
heat.
just no living
2D
quarters,
No living
no
quarters.
water, no
just a
sewer. Yeah,
2D
you'll have-
for
I misspoke.
the stone, D as in dog,
2D, yeah,
the stone drip edge and the gutter
stone drip edge,
capture.
drip edge, and gutter capture.
Let these two guys work it out.
No, this is gonna be, these are conditions, these are gonna be additions to the staff review under
Delta.
2D, stone drip edge and
Gutters.
gutters, to capture the water. So, previous to that was my findings. Did anybody else have any findings they wanna recommend?
It's a quiet dead-end road, and the garage is no water, no sewer, and no living quarters. How's that?
Sounds good to me. All right, and then I'll make my motion to approve with the previously mentioned conditions with 2D.
And the findings of.
And the fact findings that we have discussed.
All right, we have a second by Representative St. Clair. Any discussion? Sensing none, all those in favor signify by raising their hands. Opposed? And the motion carries unanimously. You've been approved. Thank
you
you,
very
good
much.
luck, happy construction season.
Thank you very much. Just a quick question. I had already submitted permits and everything like that, so does this mean I can go ahead? Do I have to wait for any documentation back from you guys? So I'll just You like you normally
Give
do.
them a
Okay, fantastic.
Call, they, from now on, they handle all of it.
No problem. Thank you, folks, I appreciate it.
No, thank you. All right. When the applicants are well prepared, I think it does help, although we, would appreciate it, I think, a little more clarity on the driveway there. Okay, so the next one is PL 2023-0028-U, it's 171 Gold Street, it's proposal to subdivide one lot into two. And is this proposal in shape for acceptance?
Yes, it is.
So would someone care to make a motion to accept this application? Moved by Representative St. Clair, seconded by Mr. Bellabo. Any discussion on the motion? Sensing none, all those in favor of acceptance, raise your hand. Opposed? And it was unanimously accepted. The applicant here and ready to go forward. Come right up.
Staff review, I could not find a difference.
The difference is F.
For the record,
Hold that up.
my name is Randy Otis, licensed land surveyor, representing Inteus Holdings. Looking to subdivide the lot as discussed. Any questions?
Maybe tell us a little bit about why you're doing it?
Sure. Best as I understand from the client, they're looking to subdivide off the so-called shop lot, which is the garage up here, to be used by 12 Belvedere. One of the owners owns 12 Belvedere Street. There was formerly a 4-unit apartment building on the remaining residential lot. And I believe at some point they'll be looking to replace that with a new 4-unit structure. But
Did you say 40 unit? 4 unit. 4, thank you.
I have a question. Does this lot have any water rights?
not that I'm aware of, no.
Okay. There seems to be an indication on the plan, I think, that there's some commonality of ownership. Let me see that. This is Paugus Bay right here. Or maybe not. Oh, yeah, it does seem to indicate that the same owner owns tax lot 350-21-23. That's across this Belvedere Street, and it's on Lakefront,
They are owned by the same owner, but
but a different lot.
the subject lot does not have any rights to across the street.
Gotcha.
Correct.
All right. All right, then. Any questions for the applicant?
So just for clarification, the two lots you're proposing are numbered 350-92.1, or -1.1, 0.23 acres, and 350-92-1.28 acres, is that correct?
That is correct, sir.
Thank you. Thank you for confirming that.
Any other questions for the applicant? Sensing none, we'll open the public hearing at 7:26 and 30 seconds. Are there any abutters here? Members of the public? Sensing none, we'll close the public hearing at 7:26:45. Staff report?
Staff recommends the board grant the subdivision with the attached criteria. Couple of points on this, under 2A, current driveway needs to be trimmed back so that it goes straight up the hill as opposed to having the little turnout that it has right now where the former house used to be. The existing garage can only be used for personal use. Any commercial use would require further approvals from the planning department. The applicant is aware of that. They need to update these green space calculations for both lots We have assurances that they meet the 10%, but we don't have the exact calculation at the moment. And as you may recall, you got your package of information last week, and then like the next day, you got a update to the staff report, and the only difference is at the very end of the staff report, item F, that would be 21F, sorry. Note on the impact fee, the creation of the lots does not trigger an impact fee, but any structure that is built on the larger lot would be subject to impact fees at the time of construction. And if the garage is converted to any other use, an impact fee may apply as well.
What about lot mergers? What if this lot were to merge with the lot, the lakeside lot across the street? Would there be an opportunity for the city to impose an impact fee at that time?
The impact fee is only applied to structures. It's not
Gotcha.
applied to creation of lots or reconfiguration of lots.
Okay, that's good to know. All right, any questions for staff? Yes, Ms. Susi?
I was looking at the green space on the subdivision plan, and I was just wondering if that is accurate.
It is not, because we are asking for some of the driveway to be, present driveway to be removed, so the numbers will need to be updated.
So you're gonna create a more pervious surface, or decrease the impervious surface? Or did I
They're going to
misunderstand that?
increase the pervious surface.
Decrease the pervious surface.
It would increase the green space, as I understand it.
Yes,
Decrease the impervious.
yes.
Pervious as opposed to. All right,
Can I just note too that on our paperwork, it says lot 350-91-1, but the actual application and the maps are correct with 350-92-1, not 91.
Okay,
Vetch?
we'll make that
Vetch.
change on the,
Not that someone down the street tries to subdivide their lot without us knowing.
yep.
That would never happen in my neighborhood.
Funny things happen in your
Just out of
neighborhood.
curiosity, the lot that you've got that little bump out, what is the plan for that little lot?
Where are you looking exactly?
The long with the bump out, for the garage,
We got one
Yes.
lot with a garage.
right?
My understanding is the owner of this property plans to store personal stuff in the garage. That's my understanding.
Could you say that again, the owner of that property, what?
Plans to store personal property in the garage. That's my understanding.
So it's the same owner?
He's somehow related to Antaeus Holdings, I'm not exactly sure how. I believe currently it's under different ownership.
And so the driveway is gonna go that way?
No, it's an existing driveway off Gold Street that
Right.
services the shop. There's an existing driveway that would service the residential lot, and his property over here has a driveway. There, the lots.
So he'll access it just by driving it around? Okay.
For now.
Thank you.
Okay, any other questions? Comments? All right,
Do we need to wait until we have the calculations to show that the two lots meet the dimensional requirements?
you mean as far as green space goes?
Because then we'd be approving the plan as depicted tonight. I'm just asking.
We have been assured by the applicant that they have a minimum 10% on both lots. Obviously, the larger lot is, at this point in time, is all green space, but if it turns out that that is not true, then they would have to come back to the board. If you want to make it a condition of approval that they meet the 10% requirement, then that's good too.
That's a good way of doing it, just so the board's understanding that they will meet the 10% requirement on both lots. Any other questions?
I got one question for the planning department.
Sure, Brett.
Dean, the way this 35092-1.1, the way that that new parcel is shaped and sized, is that still a buildable lot?
It would be difficult to, build either an addition or whatever to the garage, or to, or if you tore down the garage and wanted to build a house, it would be difficult, not
It
impossible.
would be a small structure
It could be a very
somehow,
small structure.
It's just because, like Amy was pointing out with that bump out and stuff, it's a really oddly shaped.
Yeah, I mean, and that would be the area, if you wanted to tear down the garage and build a house, that you'd have to do it in that area, more than likely, you know. It would be a shoehorn, but
Yeah.
you could do it.
Dean, if they were to construct something on that lot with the driveway, would any new construction have to meet current setback requirements, or would that be grandfathered at the existing, at what their existing setbacks are?
It depends. From a high-level standpoint, if they were to build a new structure, it would need to adhere to the setbacks. The present setbacks in effect whenever they build. If they are doing something different to the garage, like if they were to tear down the garage and put another structure in there, if they were making it slightly smaller but not conform to setbacks, they would be allowed to do that, because it's a non-conforming structure now, and if they moved it a little bit away from the property lines, then it would be less non-conforming, and we allow that kind of construction to occur. So it depends on the situation.
So if they wanted to put a 20-foot addition on the front, I'm just hypothetical situation.
Right.
They would be bound by the existing setback that, what it's meeting currently, and they wouldn't have to meet.
No, they would be bound by the setbacks
current
that are
setbacks.
that are in effect for the zone.
Okay.
Yes.
Thank you.
So is this beneficial to the city to have something that's hard to build on?
Non-conforming, we're making it,
Is this,
And
I
not-
look
Well,
at this as a
in
negative.
this particular neighborhood, this would not be unusual. But it's kind of in the, and I don't want this to sound flip, believe me, but these are experienced developers and everything. They know, they're doing this for a reason. They know what they're doing. If they are creating a problem, then they're creating it for themselves, and they're gonna have to dig themselves out of it if that's what it boils down to down the road, if they decide to do something else.
Do you know what they plan on doing?
I don't know what they currently plan on doing, but these guys change their mind quite rapidly. Currently speaking, it's a 4-unit apartment building, high-end, with lakefront view on the residential lot. And the owner, like I said, of 12 Belvedere, hanging on to the shop for personal use. But these guys could change their mind tomorrow.
But they know what, you feel they know what they're doing, and,
There may be other properties that'll be acquired and merged into this, too.
oh, got you.
The comment under 1(2)B is, obviously, they have a lot of other property in the area. My initial concern is this garage is gonna be used for maintenance and equipment storage for
Commercial.
the other properties, and that would make it a commercial use, which is not being proposed. They understand the requirement that it be used for personal use only.
Got it.
All right.
Okay. Any other questions or comments? Well, what is the pleasure of the board?
I don't understand why we're making two lots. Why did we have to make two lots?
Because they're asking us to?
But they can do what they want without making two lots. We're making a non-conforming lot. Potentially.
No, it technically conforms
No.
with the dimensional requirements. I think the only thing that was in question, if you don't mind me butting in,
Oh, answer.
was the green space requirement, which I think that we kind of discussed with the removal of some of that driveway and the turnaround point, that the two lots would then meet the 10% green space requirement. Is that correct, Dean?
Yes.
Something up there.
But you're still not able to build on it.
No, you can build on that. You can build on that lot. Any lot is buildable.
Just how creative you want to
Just how creative you want to be in the limiting factors that are applied to that lot with the subdivision. So you might have to build more of a narrow building.
That's not in the UC though, is it?
These are
believe it
big
is.
commercial.
It says
Is
it
it in
is.
the UC?
Yeah.
Yeah,
Okay.
that's just about the limits of the UC up there.
Yep.
The urban
This
commercial
is part of
district.
the gentrification of Lakeport. gentlemen.
This is setbacks.
Okay, any other
So they could do
questions?
a CUP if they wanted to, and underperformance zoning if they met.
All right. So, what is the pleasure of the board, he asks again. I wrote down the modification that the staff requested about part 2.1F. And what findings would we enter regarding this?
That's what I was looking for.
The plan meets all requirements for two lots and will not cause unwarranted density issues.
There you go.
Sounded good.
Is that a motion?
Okay, fine, yes, I'll make a motion that we approve PL 2023-0028 SU, 171 Gold Street. No, is that the one we're on? Yeah.
Yep.
Yep. For the lot subdivision, finding that the plan meets all requirements for two lots and will not cause unwarranted density issues, no matter how we look at it as being odd. Someone has a future plan for this, and we want to add in with all the staff recommendations, 2.1F, which would require them to come back with the new calculations for the green space to prove that they have met the 10%.
Or that the plan itself would indicate
Indicate
that
where
they're in
that
compliance
pavement-
with the green space
Yes.
requirements. Okay, we
that's
have a
my
motion by Mr. Bellevue. Is there a second? Second by Mr. Mora. Any further discussion on the motion? All those in favor, raise your hands. Opposed? And it's been approved. Thank you, sir. Oh, I'm sorry.
We had,
Two, I think. Two again.
Two.
opposed.
I actually abstain.
Scott and Amy.
Oh, for God's sake, I didn't call abstain. All right, let's do that again. All in favor?
Hold them up and keep them up,
Do we want to count off? Just kidding.
That's six, right?
from front to
Right.
rear.
Opposed? Two, and one abstention.
Thank you.
And the approval is granted. Thank you.
Thank you.
Okay. So do you want to do 11 now? Or do you want to get the old business out of the way first?
Up to you.
Why don't we do it in the order presented?
Phil's back there. What's he?
11.1, clarity on the planning board's role and actions related to impact fee waivers and exemptions.
Mr. Chair, I had requested that this item be added
Sure.
to tonight's agenda. First of all, just a little history. The board conducted a meeting back in September. There was an applicant in front of the board that it was on Messer Street. The applicant, it's 39 Messer Street, was proposing converting a single-family dwelling into a multifamily. There were some questions the board had about parking, shared driveway, and so on. So I believe that application was tabled to the following meeting. But it was either at that meeting or the October meeting that Mr. Beliveau had pointed out that this application was eligible for impact fee waiver, which the applicant was unaware of that. I think the planning director was not present at the meeting, so it was possible that it could have, you know, the eligibility for a waiver could have been totally overlooked had it not been for Mr. Beliveau to point out that it did in fact have that eligibility. And I thought it was commendable at the time, given the fact that this was a citizen just doing a conversion on their existing property, and so on. And I believe it was ultimately at the October 4th meeting that the board did approve the application with 80% reduction in impact fee. At last month's meeting, the board had an application, 8 Summer Street. Again, this was property owner converting basement space into an apartment, which ultimately created a multifamily unit, I suppose. But once again, the applicant was apparently not aware that they were eligible for an impact fee waiver, and I brought it up at the time. Again, just noting that we had a similar situation just a few months earlier, and it was later at that meeting that the chair made remarks that suggested that I should not have brought that up. The applicant wasn't seeking an impact waiver fee. They simply were asking for their site plan approval and so on. That left me confused. Honestly, I'm still confused. That's why I asked for clarity on this issue. I didn't feel that my actions were any different than what had occurred at the September meeting. In fact, in the materials provided by the planning department indicated that the planning board may waive up to 80% of the impact fee for this property. So, you know, that suggested to me that this was open for discussion, even though perhaps the applicant wasn't aware of the fact that they were eligible. Why that occurs, I don't know. I don't have an answer to that question. I know that the planning director had made some comments last month to indicate that these waivers were sort of handled internally, and that they have a criteria that they utilize, and I'm quite certain that the planning department has acted fairly in making those decisions. You know, so my concern is there looks like there's some inconsistency on the part of the board's actions, whereas sometimes we're acknowledging that there's an impact waiver fee. Sometimes we're not supposed to mention it. I don't know. I'm still confused about that. My thought, and I could be wrong, I thought this was the role of the planning board to determine if in fact an applicant is eligible. I mean, the ordinance says could be up to 80%. Again, I think the criteria the planning department has been using, nonprofits, community developments, given the highest consideration. But I do believe that, you know, is it a blanket 80%? Why isn't this something that's open for board discussion and deliberation? So I would ask that the chair move the question to the board and I believe this would be in the best interest of the board, honestly, is how we want to proceed in addressing impact waiver fees. Isn't that something that should be open for discussion in terms of what level of relief the board wishes to provide to an applicant? Certainly, I foresee a day when more of these kinds of waivers are gonna be in front of the board. It could be large developers, and typically, and I'm only speaking here for, I can't speak for the planning department, but I know that those have often been treated differently. So again, I would ask the chair to move the question to the board as to, do we want to proceed as we have been, preserving the status quo? Or is this something that should be open for discussion when an applicant comes in front of the board and is eligible for an impact waiver fee?
I'm not,
I yield to the chair.
I'm not sure if I understand the question. Any question?
Yeah, I have a question. I'd like to defer to our liaison from the city council who discussed this, I believe, at a council meeting, 1 or 2 meetings ago.
I don't recall that.
With Henry Lippman, Councilor Lippman had some concerns about this, saying that was,
There were certainly discussions about the waiver of impact fees, given the impact that many of these things have on city services. And obviously, one of the things we were referring to is the potential development at the state school. My personal feeling is, if Mr. McWilliams wants to bring up an applicant's eligibility or request an impact fee, he has that right. Whether this board grants them wholesale, I personally, we need to seriously consider that. This city, despite other appearances, is growing. And this monster up on Parade Road is gonna impact us, I think, a lot more than
Great
people
ringtone.
realize. And I'm probably one of the people here who will be impacted the least age-wise. But looking forward, I worry about the impact it'll have on this city. So, should he be allowed to bring it up? My personal opinion is, and I think the council would think you have the right to do that, whether we should be granting waivers wholesale and automatically 80%, which is
Well, that's
sort
my
of-
point exactly, Counselor. I feel that it shouldn't just be a blanket 80%. What, you know, you have to look at what are the merits?
But, and I think, again, this is a personal view, I think when the chair starts to talk about master plans, one of the things that ought to be included in there is a formula for this sort of thing. You know, if we're talking about a basement apartment, that may be a certain percentage. If we're talking about 1,300 homes, it's a different, if not a 0%.
Well, I feel we need a criteria or some sort of measure to be consistent in how we
Well, I
apply
don't
and-
disagree with that. I would suggest that perhaps we recommend to the staff that they propose a standard or a guideline for the board to review and make decisions about.
I mean, go ahead, Amy.
No, feel free.
I was just gonna say, I think that comes up in the discussion. The first question has to be, should that be something we bring up here? Or should it be an integral part of the application?
Yep.
Where the applicant is informed, you could possibly qualify this, but you have to request a waiver. And we can't guarantee that you'll get any waiver, and it's up to the board how much you get. That's the first part of it, because we have had people that, whether they were talked to about it, but with the whole application process, that was just some small thing that didn't register with them or not. There have been people that said they didn't know about it, whatever the case may be. But if they are informed that they might qualify, they should apply for the waiver. Then when it comes to us, it's up to us because it's impact fee. If it's a guy converting his basement into a finished basement, there might already be a bathroom down there and stuff. He's just gonna finish it. There's no impact to the public services. So in that type of instance, because there is no impact, I feel, okay, we should be able to waive the maximum that we can, 80%. If it's something else, the more units you're talking about, no matter what they do, if it's infill, if there aren't already the facilities as far as bathrooms and things like that existing, and they're gonna be adding to, it's gonna be more strain on our system, so there's gonna be more of an impact, so it should have less of a waiver, if we issue one at all. And that would be something, I don't know if we can sit here and come up with a matrix to say this is what you do, but that's in the discussion where when we look at the project and we say, wait a second, okay, you wanna convert your barn into 2 apartment units. Is there a bathroom and running water and stuff in your barn already? Or is this something that's gonna have to be tied into the existing sewer? And then we can debate it and say, hey, there is gonna be an impact, so I don't think they qualify for 80. Yes, they're doing a good thing, yes, they're converting their barn into living space that we need, but let's only give them 30%.
You know,
or
I was
20.
fully prepared to have that discussion, that deliberation, but it appeared that the board was not willing to do so. The other application at last month's meeting was a Union Avenue, was another, I felt needed some deliberation.
So then, that's what I'm talking about, that first step, we need to decide, are we able to suggest a waiver, or does it have to be applied for?
That's what I'm
for
asking
us
the board
discuss
to
it?
decide. how to
So,
approach
would
it.
you defer to staff to come up with the recommendation of any waiver or a set amount? Is that something you'd be willing to take on, Dean?
I thought you already did it.
It's part of the, okay, so, first of all, Scott, I'm sorry if you took my comments
No,
personally.
I did not.
Please let me finish. I'm sorry if you took my comments personally.
No.
What I was attempting to say was, we did not have before us a waiver application. We have several before us tonight. We have one still pending. The applicant did not file. It is fair for this board to assume that unless an applicant is requesting a waiver, they don't wish one. However, a good point has been made. If that's not sort of like on the checklist of things that the planning department runs through with the applicants, then it's possible that the applicant was not aware that they could. So that's the only point the chair was attempting to make, which was, I don't believe it's appropriate for us to be bringing up substantive matters like that after it's gone through staff review and everything else. We don't have a waiver before us. However, if you want to talk about the merits of a waiver request, we have an ordinance, 235-22B, and there are 3 conditions under which we can grant a waiver, A, B, and C. And those are the only, under the current law, those are the only conditions that we can find that would justify the application of a waiver, whether it's 80%, 60%, 20%, whatever. Has to be for one of the 3 reasons that are delineated in the ordinance. Completely separate from the issue of whether it was properly before the board. So I would agree, any member of this board can bring up anything that's within the purview of the jurisdiction of the board, including impact fees, which is specifically with, in our bailiwick, so to speak, under the ordinance. My point was, we don't have the time, the expertise, or many times the knowledge to make that part of our approval process. Are we gonna ask every applicant, have you talked with staff and determined whether you were eligible for a waiver? or any other specific form of relief, there are forms down there in the planning office. So if we don't have one before us, I don't think the matter is properly before the board. However, any board member can bring anything up that's within our jurisdiction in the context of that particular hearing. Mr. Joseph?
I just wanna go back to the automatic, idea of having automatic, applications or formulas to, I don't think that's a good idea, because the whole point of having these, impact fees is because they do have an impact. At the point that you make them automatic, like, you can waive them automatically based on formulas, like, we're just gonna have people that shouldn't have them, like, in the system, and I just think that's a terrible idea, and we should not do that at all. I just wanted to voice that opinion.
Yes, Mr. Cheney, and then,
Thank you. The reason I said I think staff ought to make some proposals to us is this. Mr. Delvecchio suggests that whether they have sewer and water or whatever, that sort of impact ought to be considered. Well, I think the city council thinks there are other impacts, police, fire, public works, all sorts of things, schools. So, I mean, all I'm saying is, if we're gonna talk about, I am embarrassed that I haven't looked at this city ordinance. I will within the hour. But we need a formula to go with what he's saying. I mean, otherwise, people are gonna game us.
well, not
I
a
agree.
formula, we need a process. We need to know whether when he says, is the application full and complete and ready for acceptance, that question implies, are all the waiver forms that apply in this packet?
But beyond that, Mr. Chairman, is, once they know whether they apply for an application, or they can apply, we have to have some sort of standards for 80%, 70%.
We do.
60%. Well,
I wanna add one more thing.
Sure, Mr.
I
Joseph.
think when we're considering the impact, they're human uses. It's not just having, like, how many bathrooms, like, it doesn't matter how many bathrooms you have if there's just one person in the house. So, I don't think we should be looking at that at all. It's, how many people are gonna be using this, or what's the implication? So,
You never know, so.
yeah, but that's what we're considering, like,
Well, it's an impact on city departments, essentially, police, fire, library, parks, and
yeah,
rec,
exactly,
and so
but
on.
it's people that causes these, it's
Yeah.
not just a structure by itself, like,
But I think what the chair has suggested just a moment ago, we need a process. That's all I'm asking for.
Dean, the ordinance itself, the first clause says, at the time of a project's hearing from conceptual review or design review as permitted, the planning board may discuss granting. So, what, does that limit, that's not intended to limit us taking action at the final hearing on the CUP, right?
No, excuse me, no.
So, the attempt there was to say, at any time, starting with the conceptual review through final approval. It doesn't say that, but I think, is that the intent? Conceptual review and design review, conceptual review is done in front of the board, design review is done in front of the TRC, or,
Which section are you looking at? I'm sorry.
I'm looking at 235-22.8, the very first sentence.
Okay, yep.
Says at the time of the project's hearing from conceptual review or design review is permitted under RSA 676, the planning board may discuss granting full or partial waivers of impact
these
fees
are mine now.
to an assessed property. The final granting of the waiver shall be made at the time of application approval. So we can bring it up at conceptual, and then we can act on it at the time of application approval, where the board finds that one or more of the following criteria are met with respect to the particular public capital facilities for which impact fees are normally assessed. A, Planning board may waive the impact fee for a property assessed with an impact fee if the developer has agreed to other contributions towards public capital facilities. And then it goes on to describe how that's to be done, that the process of it and the criteria for us granting a waiver under subsection A. B is, planning board may waive up to 60% of the impact fees for a property assessed with an impact fee if after review of the project proposal and covenant documents, the planning board decides that the project is affordable housing as defined under the law. And C, because of the urban nature of the city and the need for inner-city revitalization, the planning board will waive up to 80% for infill developing, right?
Yes.
So, that, to me, those are the only three reasons that this board, under the current law, can grant a waiver of the impact fee. And it's incumbent upon staff to have already vetted this when it comes to us for final approval, especially if it hasn't been brought up in conceptual review or design review. Because otherwise, it does appear, I mean, with all due respect to Scott, it could also appear that we are showing favoritism when we do that, you know? That's why, as a rule, the chair doesn't make a motion at this board. I leave it up to you guys to do it, because we're supposed to look like we're acting impartially. And so anyway, those are the only, under the current law, those, as far as I understand it, those are the only ones that we can, the only bases for us to grant a waiver of impact fees. Amy?
I just want to point out, Scott already did, but I just want to reiterate the importance of them. As a department head who actually gets some of that money, it's vital for my department a lot of times. We're in a tax cap community. We don't always get capital money for projects that we have. The police department doesn't always get everything they need, and this helps them provide a new software, or it puts different things in the system that we don't normally have the money to do. So it's another revenue stream that the departments can use to better the city. So I'm not a proponent necessarily for waivers. Then that's selfish completely, but there's obviously an interest in the city of keeping these, which is why we have an ordinance to start with. And I would rely on the staff to vet who they think is the developers that need it the most. So I just wanted to reiterate the importance of them.
Peter, if I could just ask Dean.
Certainly.
A couple of years ago, I thought we discussed impact fees, and you said Rochester's were even higher than Laconia's. Am I correct?
Oh, there are several communities in the state that the impact fees are thousands of dollars higher per unit of housing than we are.
I think the easier way to do it would be to make our impact fees a little more reasonable and no waivers. You know, that way it's just come in, get it, go.
Sounds like they are reasonable.
Well, they are, but as a general rule, waivers, in general, are a way for the board to do not just justice, but equity, in order for us to weigh all the different equities involved in the situation and say, yes, but the strict application of this particular impact fee may well be counterintuitive, or the developer has agreed to build a sidewalk to connect his property to the next section of property, something that the city would otherwise have to do. I mean, that was the intent, I'm sure, when this was adopted by the city council, but right now, 235-22.8 is the law. And as I understand it, it's not our job to know the law. It's the staff's job to present it to us in a lawful manner so that we can make a decision based upon that law. And that's why there are forms that say waiver request on it, in which the applicant is asked to explain why their application meets one of the three criteria set forth in the ordinance. And if we find that the criteria are present, then and only then can we decide how much.
Why weren't those forms attached to the application at the time of presentation?
Not relevant. I don't know.
That's them.
Ask staff. I don't know.
Okay, well, how are we supposed to make a decision regarding the merits of a particular
Well,
application?
I think that the chair outlined the three reasons that we could grant a waiver. But when you read that, there obviously, as the board makes that decision, it is subjective on your part. It is your opinion as to whether they qualify or don't qualify, and at what level. So I don't think you can 100% remove whatever perception some folks may perceive from that proceeding. But to go backwards before we even get to conceptual or whatever plan or site plan approval is that we in the department are trying to make that determination. Do they qualify for one of those three reasons for a waiver? And if they don't, quite frankly, we don't discuss it with them.
Right.
You know, we don't discuss, if someone doesn't have a wetland on their property, we don't discuss with them the need to get a waiver for wetland delineation or any other multiple of reasons. When we look at it, it's like, you don't need to do this, so therefore, we're not even gonna talk about whether you apply for a waiver or not. In theory, every single lot that comes in here should be wetland delineated. But the reality is, we can do a drive-by and look at it and go, there's no need to delineate any wetland here, so therefore, we're not gonna consider it. I mean, we have to be reasonable about these things and practical and try to use some common sense. So, I mean, if you look at the back of my memo, we've got, thank you, Kalina, by the way, for doing the research. So we've got the 10 or 11 waivers that the board has approved. They were all at 80%. You know, it's a wide variety of properties for a lot of different things, and several of these were before I was here, and I'm not, that's not a ding on anybody, that's just, you know, the reality of the situation. But, you know, in my determination of whether I think they could qualify for the waiver, it's somewhat subjective from the standpoint of, A, the stated goal. If I read Councilor Lippman's comments correctly, the stated goal is we want to collect these on every single situation because we need the money. We want the money.
An impact fee is a tax, and it's a very specific tax.
It is.
And it's designed to generate income, right?
Yeah.
Okay, so I think we are all in agreement on that.
Right, so then it becomes down to, if we want, you know, we're given the opportunity to grant waivers under certain circumstances. You know, if, this is a bad example, but you'll get it. If on one of the new lots, one of the vacant lots at Aqua Vista comes in to build a house, do they need a waiver? They don't pay impact fees because they were approved before we had impact fees, so that's why I say it's a bad example, but it makes the point of, I don't think there's anybody here on this board that thinks someone who's building a $700,000-800,000 house in Aqua Vista needs to save $4,000 on their impact fee.
But
So
even-
who's gonna grant that, you know?
Even that-
But when you have the Sunrise House over here in the corner of Union and Elm, why do we want to make a nonprofit organization that is trying to create very specific low-income housing in the city? Why do we want to have them pay more in their construction costs because we're going to impose the impact fee when clearly under the ordinance, they qualify for the waiver? So, I mean, from the get-go, when they came in with their application, we brought out the fact that they're eligible for the waiver right from the get-go. But there's a lot of applications in between those two examples that it's subjective, it's in the gray area, it's, what do you want to do? The two tonight are in that gray area. You could determine that they meet the qualifications and grant the waiver, and maybe you don't. And I'm not 100% sure what my thought process was at the time when we discussed these two plans with the applicants in the office, but it's fairly obvious that the concept of the waivers either was not brought up or was not, a primary focus of the discussion. So
Dean, I agree with you, except that I would take exception to the use of the word subjective. We have to make our decisions on the record, based on the merits. So if the information is not provided to this board, then we have no obligation to act. It's on the applicant. It's up to the applicant. They have the burden of proof. They have the burden of persuasion, shall we say.
Yep.
When they come before us. We rely upon you to vet this stuff so that if a worthy waiver applicant is standing at your counter, that you offer them the opportunity to investigate that. But it's still on the applicant to meet the burden of persuasion. They have to stand at the podium, even if they don't understand it, and say, we would like a waiver because we've agreed to buy a new substation for the city at their, or whatever. And it shouldn't have anything to do with whether the applicant is well-heeled or not. Doesn't say anything in the ordinance about the ability to pay being a factor on which we can.
You're right.
All right, so that would be subjective. We can't do that.
Yeah.
It has to be based on whether or not the applicant met their burden of convincing us that one or more of these three delineated exceptions exists. Councilor Cheney.
First, I'd like to apologize to Mr. Delvecchio for blaming him for the toilet conversation when Mr. Belvo was the one.
We just assumed you didn't notice that they changed chairs and, we make some allowance for that.
For old age, I understand.
No, I didn't say that.
No, I know you didn't say it, but everybody
We
here
thought
knows.
it. You have a lot on your mind.
And I'll file a complaint later. Listening to this, I think it's incumbent upon me as liaison from the council to mention to the council it's time for a review of this. And, let's see if we can tidy it up. I don't know. I mean, the ordinance and operations, is it, committee, could meet with this board and try and make sure we've got the best language. Obviously, if a number of other towns have impact fees, the danger is they'll see the dollar amounts and go higher, but other than that, I think we can look at what's going on in other places and maybe tighten up what we define as a necessary criteria for application for this.
I wanna add another thing, to what, the example Dean gave about someone building affordable housing and they meet the requirements. I think we also have to think that the city needs this money, so even if the people have good intentions, like, we still need the money, so we shouldn't just always just like, oh, you qualify, you get it, like, I mean, we still need the money.
I overpowered my friend here.
Yes, Mr. Moore, and then Amy, will you, no, you, and then Stacy.
My only concern is, and the only thing I want addressed is, I think we need to be firm, fair, and consistent with everybody that comes in the door, of whether their property is eligible for any waiver, whether they want to apply for it or not, but we need to be open with them as part of government transparency, I believe.
That's
I believe
what
that is our total function here as a municipality, is to be a transparent government, and everybody, regardless of what their project is, that meets requirements for a waiver, they are made aware of that.
Right. And you would agree also with my statement earlier that it's perfectly proper for any member of the board to bring it up for the first time, just not preferable.
I 100% agree. I just think it needs to be brought to their attention before it comes to the board.
Yeah, because otherwise they're standing at the podium and they don't even know what the criteria are.
I don't even know what a waiver is.
Well,
My God, if
yes.
So you could
All
say
right.
waiver eligible impact.
One more from Stacy, and then we're gonna move on.
Okay, so I was going to propose that we completely discontinue the waiver because I felt it was too subjective. And I did some research and I looked into RSA 79. And we might actually even be under this already, maybe? It is residential property revitalization zone. So the city can establish tax relief for owners of 1 to 4 units of housing property who significantly improve their existing structure. All it has to be is at least 40 years old, but it has to be located within a locally designated revitalization zone.
We do have that as a city, and the city manager manages that program.
So if it's already in place, we could just discontinue the waivers and forward people to, you can get tax
Did you
relief.
say 79, RSA 79?
79.
Dash E.
Yeah, 79.
Oh,
But-
79
But
E.
from what you're reading, Stacy, the way I understand that is if I already have 4 apartments, but they're dilapidated, and I'm gonna improve them and renovate them, then I should get some kind of tax relief. It's
So-
not necessarily changing from a, say, a barn into two.
Right, if you've got 4 units that are run down and you are going to rehabilitate them, you don't suffer an impact fee, because you're not creating an additional living space. It's only when you're creating a unit of housing or square footage of commercial, new square footage of commercial. So, take one of the empty storefronts downtown. If somebody new goes in and puts $100,000 into the storefront, refurbishing it and making it nice, there is no impact fee, because there's no additional square footage created.
Right.
If they bump out onto the side and add 1,000 square feet, then we're gonna impose the impact fee for the 1,000 square feet.
And this
Well, and
is,
what Stacy was reading, though, wasn't talking about impact fees.
No, it's a
That
tax
was talking-
incentives.
Yeah,
it's-
tax
It's property
incentives.
taxes.
Yeah.
And so they could get both if someone was gonna create additional units of housing.
well, we
A
have.
good example is 51 Elm Street did
51 Elm Street.
79E.
Right.
But they came before us
But
and
we
said they
don't-
were gonna create, new housing, right? Affordable
Right.
housing, and now they're all condos.
But 79E doesn't come before the planning board.
No.
That's not our jurisdiction.
No, that's true. But
Right.
what I'm getting at is,
And they did-
we're given the tax incentives.
Right, because that's a different incentive based over,
Right.
over
That's a tip.
time, over so many, correct. So over so many years, they get that reduction, until it comes.
I think it's the same, it must be under the same statute, right?
I'm more than happy
Community
to-
reinvestment, revitalization.
I'm more than happy to add a checkbox to the
application.
application that will prompt them to ask if they qualify for an impact fee waiver.
And if we don't see one of these, and it doesn't say in the agenda, you always have requesting a CUP and a sidewalk waiver. If it doesn't say an impact fee waiver, then you have already put them through that evaluation process. So we shouldn't ask the questions.
Hopefully that's the case. Can I sit here now and guarantee you that we have done that on 100% of everybody that we talk to? I'm not gonna.
If we
say
were
that that's
100%
gonna-
correct all the time, there'd be no court cases against the city.
You know, the thing is, you could request any number of waivers in a given site plan application.
Right.
And where do we where do we put the onus onto the applicant to know?
I think all you need to do is
Versus where
make
we've
sure.
got to inform them, give you an example, the infamous sidewalk waiver. I don't, I shouldn't say I don't. Very, very rarely do we say to an applicant, oh, you can get the sidewalk waiver. Because I know what the discussion's gonna be here, and I'm not opening that can of worms, okay? But the people who do development all the time, they know,
But I think that's a different waiver, though. That's waiver out of the site plan and subdivision regulation, as opposed to a waiver out of the zoning ordinance.
Still a waiver.
Well, but the site plan regulations are approved underneath the zoning ordinance. I mean, they
Right,
are,
but we can change those easy as pie.
well, this board can, yes, you can, yes.
And we could eliminate that altogether, and then that would even be,
But we cannot amend the ordinance. only
right,
the
without
city
going
can
through
do that.
city council and doing it.
And what we're talking about is a waiver of a city ordinance, not a statute, so. think
My only
Stacy's
point
point's well taken.
is at some point in time in the future, not impact fees, someone's gonna ask, were they advised of the fact that they could get a waiver? And the answer's gonna be no. And then I can put another checkbox on the thing. We can do this, forever, which I'd rather not.
I think there's a term that comes to mind is due diligence.
Yeah.
Any applicant that stands before us has a duty of due diligence. They need to look into the ordinances
Check off
that
that
apply to
you
their
understand
development,
could
whether
be,
it's,
or you don't do your due
a
diligence.
non-professional
As long as
person
everybody
that's
knows that
simply
there's an
making an
option for it.
addition to
That's-
the
that's
family home,
That's all I really
or
care
a
about.
professional developer. They
Consistent.
still have the burden of persuasion when they stand at that microphone. And I think, I could even say I would expect that if staff believes that there is some merit to a waiver, and it's a meritorious applicant, that the staff will bring that up. But as he just said about sidewalks as an example, unless they bring it up, they're not gonna bring it up. For the same reason as, or whatever, Councilman Lippman's comments were. I mean, this is an income, to the city, and it can't be, without good cause, reduced. And we determine whether the good cause exists at the time of the final approval. So the sooner it's brought to our attention, I guess, the better. And any member of this board is free to go to the planning department and review all the pending applications. It might be helpful, I think, if we were to get, maybe a list of whatever's, in the pipeline, more than one meeting in advance. When the TRCs meet and what the approvals are, and get some idea, because that way we won't be as surprised as we were on several occasions in the past couple of years. That, oh, yeah, there's a waiver here? Or there's an eligibility for a waiver? I don't know. I don't have a solution. I've offered my apologies to you, Mr. McMaster. I certainly didn't, I didn't attempt to, yeah, whatever. McWilliams?
No
Right in the
offense.
crowd.
Master McWilliams, yeah, no, absolutely did not intend to give offense. I stand by my sentiment anyway. This one final comment.
Can I end this with my favorite definition of a land use board? That'll put us all in a mode. We are here to balance the rights of property owners versus the needs of society to regulate how property is used. We are a quasi-judicial capacity that looks at the effect that use has on surrounding property and community.
And the quasi-judicial means we make the decision based upon the record, not based upon our personal knowledge, with the exception of the fact that we don't all go out and do site
Beautiful
visits.
definition.
Stop it.
She's been waiting to say that for 5 years.
I know. It's a point well taken, and
It would have meant so,
We are here to balance.
it would have
You
meant
like-
so much more as the vice chair.
so as I promised, We are gonna move on. We have some folks out here waiting for us to move on.
Let's get on.
Dean, accessory dwelling units, are they subject to a waiver, impact fee?
Except during bike week.
We've granted accessory dwelling units,
They
and I
are-
don't recall,
They are not, because under state law, when the state, it's 2016, revised the accessory dwelling unit. Well, we adopted in 17, but they passed it in 16. They specifically stated that an ADU is not a separate unit of housing.
so not subject to an impact fee.
Right.
Very good, thank you. Let's move along.
Shall we? 12.1, waiver request. What a coinkydink. 686 Union Avenue. Oh, this one's, I've got marked continue to May 2nd per applicant. All right, so we don't have that one. So we have 8 Summer Street. I wondered why you hadn't left. And you know, it's funny, because I just saw your name, Mr. Otis, on a waiver request based upon infill, basement, low-income housing.
Yes, sir. As you know, I'm trying to convert my basement into a place for myself to live in the city, and the office building is about 350 feet away. So I'm trying to get affordable housing for myself, selfishly, that enables me to work in the city. I believe this qualifies for infill of low-income housing in the urban sector.
Okay. Any questions for the applicant, based upon our... So here's what it says about infill. The planning board may waive up to 80% of the impact fee for a property assessed with an impact fee if, after review of the project proposal and covenant documents, the planning board decides a project is 100% infill, rehab, and reuse. So we have to find, to a reasonable degree of certainty, that it is infill, rehab, and reuse, which is defined at, I know I saw it here somewhere. Oh, it was in your memo, wasn't it?
Yes.
It's at the very bottom.
Any vacant building on a lot or parcel within zoning district C, CR, or UC where at least 80% of the land within a 300-foot radius of the site has been developed, and where water, sewer, streets, schools, and fire protection are already provided, and the property's been remodeled, interior and exterior, other than ordinary repair and use for constructive activity. Okay, you're standing before the board telling us that all those things are true regarding your property?
Certainly upstairs is occupied for sure, but the basement is not. Whether that qualifies to the letter, I'm not sure. But this is space that is not currently being habited or used to benefit the city in any
Okay.
way.
And you're located in which zoning district?
I am urban commercial.
Okay. All right. I think we can take judicial notice of the fact that 8 Summer Street is within a 300-foot radius of developed land where water, sewer, streets, school, and fire protection are already being provided, so. Yes, Mr. Belleville.
Do we know what the impact fee number is right now?
Is it on the application? No.
I could tell you, yep, just real quick here.
This was last,
It's my coffee stain notes.
That's all right.
Yeah, I know.
Because the other waiver request had listed.
can you just read,
I'm
if
just
somebody
wondering.
has that, can they just read it off?
I can just read it off to you in just a second. Yep. For multifamily, this is will be a multifamily structure with the 3 units. It's $3,481.37 is the normal impact fee.
Give me that again, 3,000?
3481.37.
And,
They got that 37.
and times 80%, right?
Correct. Or any percent you'd like to do.
I can't find that, there it is.
I just wanted to know in relation, so I'm not thinking 10,000.
So 80% of that is
200.
$2,785.09, 10 cents. Am I getting that math right?
That would be how much you take off, yes.
That's how much you would deduct from that first number. So the, jeez, I'm terrible. I can't even do math with a calculator. What was the original number again?
3481.37.
3481.37.
$695.51, I believe.
I got 696.27, but.
Yep.
696?
Yeah.
Yep, 696.27.
I had 695,
All right, well, you owe me a coffee.
always.
Which means Amy gets $2.
$2 for Amy? As her impact fee?
Thank you so much.
You're welcome.
Don't spend that in one place.
I'll try.
Okay, so, are there any questions for the applicant regarding this waiver request?
I do have a question.
Sure.
So this is in a basement. Are there bathroom facilities in there?
Not currently, no.
But there's going to be.
Yes, sir.
Obviously.
Really?
Well, I would hope so.
Is that a question?
It's a statement.
There's
Mm-hmm.
Outside.
And I will point out that in addition to whatever impact fee is assessed on this property, that in addition to that, because he's adding additional fixtures to the sewer, there are going to be sewer department charges, there will be water department charges, there will be, you know,
Additional income
yeah.
to the
So-
city.
So they'll, even though all he has to do is hook up to the current pipes,
Changes the fixture count. Water department
another
bills on
meter.
That'd be
and
another
all that
meter.
this
stuff.
fixture, part of the billing equation is the number of fixtures.
and what other possible costs could there be for the city, other than that?
None.
It's just another user.
Well, I mean, there's.
One
there's-
more,
there's-
one more inhabitant of the city.
I mean, there's
More
treatment,
resident.
obviously, there's treatment costs, but, I mean, in theory, at some point in time, this additional unit of housing potentially adds to the need for the city to expand the system, whether it be a bigger pipe on that street, or whether it be a bigger pipe that goes to Franklin, or whether it's, you know, whatever it is.
But that
It's a-
goes to the intent of the ordinance as a whole,
Exactly,
not
yes.
this particular
Right.
Right.
applicant.
And last question, is one bedroom,
Yes, it's a,
one small bedroom?
yes, it's a roughly
Well,
500.
The reason I'm asking that is because if he moves out,
And,
a family of six moves
Six
in.
moves.
What's that?
You're gonna ask him how big the mirror in the bathroom?
Not at all. I'm just asking about the family of six moving in when he moves out with 5 kids or something. So that's why I'm asking that, because that came up in our discussion about impact on schools, so.
One bedroom, I don't think you're gonna have school kids in there.
What's the square foot?
What's that?
Might be surprised.
I guess I might be.
550, I mean, it's a,
It's a 550 square foot.
it's a studio.
Many school kids were actually conceived in a small bedroom.
Oh, my,
Well, I would,
I don't question their conception.
wow,
It's not my purview.
I gotta go home.
it sounds like that this is a good case for the renting.
Goes with the pantyhose tonight.
I'm just saying, but that's just my opinion. I'll let somebody else run with it.
What was your opinion again?
It doesn't matter now.
Somebody was gonna run with it.
Oh, my goodness.
Okay, so if we could get back to the matter at hand, is that the only thing that's pending here, is a waiver request?
On this.
What, and
On
what
this
is, and
agenda
what,
item?
Yes.
Yes.
Yeah, okay. So, what is the pleasure of the board? Do you need to weigh in on this any further? Okay,
staff recommendation.
Well, we're gonna read that.
Should be $700.
Can I just ask a question to the planning department real quick? Mr. Chair? Is this how we normally handle waivers under new business? post-application
no, we-
approval, or
we-
is this something new?
No, we usually do it at the same time as you're acting on the main application.
Which was last month.
Right.
And that didn't happen
But
because.
almost all of them before that were handled at the same meeting as the main item.
And this was different because the applicant wasn't aware of the waiver at the time?
Correct.
Okay,
Just wanted
okay,
to say
thank you
that
for clarifying that.
What did it say?
Okay. Can we have a motion, or
I don't know. I know.
Something?
I have a motion, if it flies. I'd like to make a motion that we give a waiver, I'm not gonna give you the percentage, but it just makes it a flat fee of $700. Cause it's easy math. No
But you
pennies.
gotta figure out what the percentage is, because we can only grant a percentage up to 80%.
the ordinance requires it
$700.
to be
Without
a
a calculator.
percentage?
It's less than 80%.
Yeah, it's gonna be
70%.
74.6572.
That comes out to 70%?
Take 70% off
Almost.
of 3,400.
As long as it's $700.
$696.27
As long as it's $700.
Not how the ordinance works.
I think we should follow
What's
the
that? But he
ordinance.
came up with a percentage.
That's
We can't-
80%,
we can't-
that's the
Does it have to go to 80%?
$4 short of the
No,
700.
it could be any number you want.
Okay, so I'm just saying, whatever that percentage is, to a fee of $700.
Why,
You know,
Charlie?
that
Because
take-
it pennies, I mean, come on.
Because the ordinance says percentage, not dollars.
Okay, so he just said it's 70%, so I'll make it 70, if that's
Give
what
or
it
take a
is.
few pennies.
Oh, jeez Louise,
That's not
okay,
exact science.
whatever, make it pennies, it just makes me nuts. Yeah,
Okay,
I'll throw the pennies on the table and that'll help.
so 70%, is that your motion, Representative St.
Is
Clair?
that what that comes out to?
That's $696.
I'm sorry?
80% is $696.
Fine,
That's close enough.
That's
So
close
80%, that's the max.
That's
just
the
donate the $6 to the
ordinance
city.
says.
I'm not sure if we have a motion. Do we have a motion?
I just made a motion for the 80%.
80%. Is there a second?
Second.
Second by Mr. Belleville. Any further discussion? Sensing none?
What would Henry Littman say?
Well, you'll know at the next city council meeting. But I think this is,
Is that his board?
I think this is exactly what the spirit of granting waivers should be on something like this project. Because it's not gonna impact the city, except for possibly more use of the sewage and water and.
Well, you get a professional moving into the city. Thank you for coming to Laconia, Randy.
And he pointed out, and it was pointed
the
out that,
weekdays, anyway.
that there are fees from water and sewer that will be incurred, and they're gonna be paying for that. So it seems like this is exactly what the type of thing that should be waived.
We have a motion and a second. Any further discussion?
Yeah.
Sensing none, all those in favor? Opposed? All right, so we have 3
Abstain.
opposed and 6 in favor, and that motion waiver carries.
Mr. Chair,
Yes.
if I may, I have 2 more items under old business.
Okay.
the second, the third one who opposed?
Jeez, I thought we were all in
set?
favor of that.
So,
So long.
thank you, Randy.
Appreciate it.
Come again.
I wanted to appraise you of a situation that we have concerning the 90-unit apartment complex on Province Street. As you know, you approved that last year. We have been working with the applicant to bring this to fruition. They have applied to the New Hampshire Invest program and are eligible for all kinds of funds from the state, and we are eligible as a city for all kinds of funds from the state if this is developed. So and this is affordable housing, under the criteria set by the state, the income levels and et cetera, that the state has set for Belknap County. As you may recall, the plan was to have their second driveway, which they are required to have for fire code reasons, was to go up through the park, that part of which is the dog park, but there's more to that acreage than just the dog park, but up through the park and connect with Growth Road.
Who is this?
The city obtained the money for the park through a federal program that requires that the land remain recreational in its nature.
And open to the public, it's federal.
And open to the public, right. So, the plan here is to find another piece of land, and I know that Amy and the city manager have been working on this for several weeks now, is find another, an equivalent piece of land, approximately 2 acres, that we can basically do a land swap on, so that we can have this easement go up through the city land for this project, and somewhere else in the city, that 2 acres of land will be designated as recreational area. That is what we're hoping to accomplish. However, the process to do that with the state organization, the department of the state that takes care of that, and then the federal government department that takes care of that, it's a lengthy process, probably up to a year or more, to get that accomplished. In order for the developer to start development of the apartment complex, and therefore, down the road, quite selfishly from our standpoint, to try to receive almost $900,000 from the state as our city's share of what this project would represent, we would very much like this project to happen, and it needs to get going and get started post haste. So while that is Plan A, the original plan that you approved is Plan A, and we hoped to achieve that, we need a Plan B so that the developer can start construction within a month or so. And there are a couple of Plan Bs, but I think the one that we have settled on is to take the one driveway from Province Street and create what's called a boulevard plan, i.e., instead of one driveway with 2 lanes in it, it is a driveway that has 2 lanes, but separated by some amount of divider, medium strip or whatever. No, it would still be 1 lane in and 1 lane out. It just, they would be separated by a medium strip. The idea behind the boulevard plan is that if there is a car accident or something, you know, halfway up the driveway, that prevents people from leaving the project or prevents emergency services from getting into the project, then they have an alternative. That was the reason for the second driveway, and under the boulevard plan, the fire code allows for this separation of travel lanes so that hopefully, if you have a car on fire or an overturned oil tank turd or something like that, there is a driveway that at least emergency vehicles can use if they need to. That's Plan B, and I'm bringing this up to you to find out, to try to get a little direction from you of how you would want to handle and document Plan B, hoping that we don't have to do Plan B, because Plan A has a lot of advantages, and the developer wants to do Plan A.
Plan A is the land swap.
Yes, yes.
Well, that's up to the city, but, and in fairness, Amy was quite instrumental in this because Dean suggested that, as you remember, and we picked up and ran with it, and all throughout the approval process, I was in touch with the former city manager, and you know, he was in touch with Dean, and it was no problem, the easement was no problem, nothing was no problem, but as Amy pointed out at one of our meetings, she wasn't on the planning board then. So basically, we kind of found out about these strings, so to speak, attached to the federal money that was used to purchase the property, you know, through Amy's expertise. But in any event, Amy has, you know, I'm gonna let Amy talk here, because she knows more about this than probably all of us. They have found another site. There's actually a substitution clause that if you come up with a substitute property, you can do this. So it's, even though we have to wait a long time, a year or so for this, there's a very good chance that it will happen, because the land they have is exactly what they're trying to do. And obviously, the water line goes under that road too, and obviously you can still have recreational land with a water line under it, because the water line doesn't do anything to avoid anybody
But you recreating. can't have a driveway or a road.
Exactly correct. So what we're looking for is something like what you did at Langley Cove, a temporary secondary access above 49 units, and permanent secondary access in the event the secondary access over the city land cannot be obtained. And besides the financial end of what Dean mentioned, this is like a $25 million project. It's been financed through bonds with the New Hampshire Housing Authority and the revenue side. And it is guaranteed like workforce housing that's in the deed, that there's like 80% of the median income is gonna qualify to live here. And the permits are either pending or they've been granted, and we're kind of ready to go. And the person that's doing this is the largest and most experienced apartment developer in the state, Mr. Dick Agnost, and he needs specific wording for the housing authority to finance this. And I never like to come to a board like this and say, gee, you can't use your discretion or whatever, but we're kind of stuck right now. But I think I'm gonna let, again, Amy talk, but we're pretty sure Plan A is gonna work. It's just gonna take some time. And we do need a temporary secondary access, and obviously you can't spend $25 million based on a proposal if you're never gonna get a final
You're
approval.
just trying to get a sense from us. You're not asking us to take any official action tonight, right?
Well, I was kind of hoping we might do an amendment for temporary secondary access.
Without notice, without a public hearing?
Well,
I don't think we can do that, Phil.
okay, well, whatever we can do, but I'd still like Amy to talk, because she knows more about this.
I would
than
love to hear more about this, yeah.
Yeah.
We want to work with you, but this is, again, we're a quasi judicial board, you heard it.
You like that?
I like that.
So basically, what both Phil and Dean mentioned is fact. The process is not cut or dry. It's very convoluted, and as you tend to get with the feds, I'm sorry, that's on video. But we're gonna have to survey, and we're gonna have to do these things. The land swap, we have to take the amount that we're going to be using at that facility and produce it somewhere else. We have a couple of different spots that the city already owns, and a potential spot that the city's looking at purchasing, the one behind McDonald's, part of the rail bed that's already a walking trail. One thing that they.
Black Brook?
Yep.
Oh, yeah.
One thing that the state and the feds are requiring is that it become a recreational facility. One of the spots that we're looking at is Davis Place. I don't know if you're familiar with it. But the city already owns it. It's about an acre and a half ish. But it's right on the water's edge, so and it has a parking lot and could be a great car top boat launch.
Is that to the, not straight down the end of Davis Place, but towards the left,
It's on the left, yes,
behind the housing?
yes, yep.
There used to be a warehouse or something there, maybe 40 years ago.
So that is already city-owned property, so we're not looking to
So
purchase
that could be
anything other than.
canoe and kayak
Correct.
launch or something like
Correct,
that?
it's something that we could add to the roster of LWCF, which is the grant that we purchased the land at the South End Park.
So the
So
dog
how
park was,
long- how long
South
do you
End
think
Park, yeah,
it'll
it's
take?
a long time,
Long,
over a year,
over a year.
And-
Why does it take so long?
lots of red tape.
Speed of government.
And
Lots of red
remember,
tape.
part of this program is when that right-of-way comes through the apartments, the whole entrance of the dog park's gonna be all redone and
Oh,
be
right.
nice. Yeah.
Yep.
so the dog park will stay where it is, and all we're doing is, it's kinda like you're utilizing that land possibly at the end of Davis or whatever as a supplemental piece of land to add to that total quantity.
To make up for the.
The
right
total
to
piece that we're
easement.
taking out.
Do we
According to
know
me, it's the street
the area of that right-of-way for the secondary access?
It's like 1 point something, but it's an easement. We're not actually getting the property, we're just getting the right to put a
Intersection
road.
But because we can't have it recreation, that's when
That's where it comes in.
this comes out, and
So
a
one
road is
point
not
something
recreational.
being like 1.1 or 1.9? Closer to 2 or
No,
closer
1
to
point, less, closer to 1.
we're up there. It's, we're gonna be all right. We have property as long as the state, and the state's helping us work through this. They're the Fed's liaison as the LWCF liaisons. And so they'll work with us, they'll come visit the properties, that kind of a thing. And they're trying to work with us. They're, again, a little convoluted sometimes in their emails. We're trying to figure out exactly the process, how it works, because we've never done this before.
And again, it's an access road. I mean,
Correct.
it's not gonna take away from anyone recreating at the dog park. And I would like to say one thing. I think if you're all aware, there were quite a few necessary conditional approvals. AOT, joint use agreement with public service. We have got everything except this issue taken care of.
Phil, if I may, in the, you had a new driveway possibility in the easement of the, yeah, so
This is the boulevard thing that he was talking about.
Oh, no, the new driveway that you had in the easement of, the PSNH easement, the Eversource easement.
I don't have that with me.
No,
Yeah.
I just wanna bring it up. There was an option of moving it into what we already have as an easement with the Eversource. They had their easement before we bought the property.
Right.
So the power lines go through there, and what their idea was to move the driveway or the road access into that easement that's already there. I can't put recreation technically, or I shouldn't,
Under
put it right
power
under the power lines, right?
The one would hold, no.
Go
They dis-
four-wheeling.
They disagree with me.
I know.
So that's exactly what they said,
I
oh,
did
you
as
can
a kid.
four-wheel, you can do all these things, and oh, that ruined my whole idea.
Where we grew
So
up
I'm
riding
assuming that is off
motorcycles.
the table?
Because they said that, yeah.
Okay, I just wanted to verify that.
Okay, so what are we gonna do tonight?
I don't, you're correct, Mr. Chair, you can't do what Attorney Brouillard suggested. However, so the fire chief, so the need for 2 access roads is a fire code.
It's fire, yes. I
The
understand.
fire chief has done some research on the fire code, and the boulevard option is allowed under the code with the approval of, in our case, the fire chief. He believes that that is an acceptable solution. The only question that we have at the moment is how wide that medium strip needs to be in order to qualify as enough separation, and there is some limitation there of the width of that little panhandle of land that the driveway is going down, so.
Because there's some drainage ponds.
There's
down
drainage,
here.
and there's slopes, and there's, so there are some limitations there. You try to get too wide, it kind of falls apart, so we need to nail that down. However, I think that if you wanted to approve a conceptual idea that if we need to do this formally in the future, that the board is receptive to making an amendment to the site plan to allow for Plan B.
And-
Otherwise, we
and
stay
let-
with Plan A.
And let me just say that we're still committed 100% to Plan A. But again, like what he's saying is that this is a temporary secondary access above 49 units would be this boulevard plan.
Right, get you.
So we're not, and so if that's what we're really looking for, to make sure we can build and keep going, and that eventually we'll get to where we need to be.
Okay, so if I understand it then, the option A will take up to a year, if not more.
That's-
Option B, could be noticed and approved next month, right?
Well, yes, but we still want to do option A.
Then it's gonna be a year or more before you can do that.
Well, not if we have a temporary secondary access like you did at Langley Cove.
You mean, you would stop building at the threshold of the number of units that you need in order to have the secondary? Is that what you're talking about?
No, we would put in the secondary access, the second part of the boulevard, above 49 units.
Oh, I see.
They did a temporary road up at Langley Cove, where the sewer line was it about a year or so ago?
Yeah.
Yes,
And that's where they got away from, because they had that temporary second road there, correct?
so the approval that you approved with the access road would stay. So what you'd be doing is adding a temporary secondary access above 49 units, and obviously, and a permanent secondary access in the event the secondary access over the city land cannot be obtained, but from all we can find out, will happen just given time.
Well,
But
I think-
we gotta have fire code access to the project if that, for some reason, doesn't happen.
yeah, Brett,
If I remember right, this was proposed as a single-phase construction.
It is,
Okay.
but you can
Because
only
with-
build one building at a time.
With Langley Cove and the other one, there was hey, we haven't sold these lots, so we don't need this access until we get there, and then it was talking about kind of phases.
Right.
But you're planning on building everything at once, so you need a secondary access.
Well, we-
So we would approve right now, we would favor the conceptual design for this temporary boulevard
Subject to
access.
some tweaking. that he
Subject
said.
to some tweaking, and then when you actually come with the amendment for option B, that doesn't negate the A. The end game is still doing option A, but to allow you to complete the construction, you have the temporary.
that sounds, and I don't think, I'm speaking for the board as a whole, I think. Whatever acceptable, reasonable application you wanna make, we can notice it, post it, and act on it next month.
When's the deadline?
Tomorrow.
Do you
Tomorrow
think-
is the deadline for next month?
Deadline for 2 months, but yes.
Do you think you'll be able to work things out with the chief by then, Dean?
Well, I think as long as we get an application in a drawing on a napkin, it'll save your spot.
Well, we've
Right.
got a
It's next
little
month.
bit better than a drawing.
And the okay from the fire chief by next month's meeting, so we can see that.
Well, I was kinda hoping that, John Roke's got the plan, and he sent it to everybody, and we hadn't gotten any comments back, so I came to the meeting and to try to discuss this with everybody. And, basically, if there's some changes that we can make and get the plans in, I can certainly, file it with the plans that we have.
Okay, well,
And it's probably
no
gonna
one
be,
looking at me, I don't,
Because they want to move.
if they wanna go home,
I know, well, I wanna go home too, but I don't see that there's anything before us to
Okay,
approve.
all right, that's fine, yep, no, that's fine, we'll process an application for the next meeting.
Dean, is that where were you looking for us to do something else?
Conceptual.
How many people are in favor of that?
Do you want a?
You want us to vote on options A, B, and C, D, E, or?
Do you want us to say that we're in favor of it, or what are you looking for?
This isn't gonna move us
Approve the
forward.
concept?
Yeah, this is just like a conceptual review at this
Yeah.
point.
favor of the conceptual review.
Approve the concept, yeah.
Yeah.
Of having, Plan A and B in place, and with Plan A being the preference.
Is that a motion?
There's a motion.
Second.
Motion made and
Conceptual
seconded.
review does not require notice. It can be wide-ranging, but not making decisions. Non-binding, free-flowing conversation.
And we are Quasimodo.
Seriously, take that book away from her.
Any,
Do you need a job?
This is what happens when you retire.
The concept of,
the concept of A or B, or some combination of A and
Submit
B.
an application and the plan, and we'll review it and vote on it next week.
Well, it'd be
next
an
month.
amendment.
But we do still have to notice it, and,
Yes.
and
Well, it's just gonna be amendment to the the
Existing.
initial access.
that's exactly what I meant.
And he can keep both those approvals of,
Oh, yeah.
both those options on the table of.
yeah,
Yeah,
Any further discussion on the motion? Sensing none, all those in favor? Opposed? Abstentions?
Thank you all.
Thanks for being patient. I wondered why you were sitting there, Phil, all that time.
one more item under old business.
Oh, good.
Hopefully this will be much quicker here.
I'm not seeing this.
let's revoke it.
Yeah, I know, I'm sorry. Last month, we discussed
11:05.
1103 Union Ave and the used car business and parking where they weren't supposed to be parking.
Yeah.
With your very stern collective words, I went and visited the business and told them that I'm going to bring them before this board and with the possibility of revoking their site plan if they don't correct their error of their ways. They have corrected the error of their ways
So far.
since my discussion, yes.
Yes.
And today, when I drove by, they had some cones sitting out in that area so that not even their customers can park there, which was their
That's
claim
cool.
was
'Cause
happening.
The day that we had that conversation, I drove up there, and there were 2 cars
Yeah,
parked there.
I understand.
So,
So they've been very, very
and that's
consistent.
when I told him, I said, just tell them that we're gonna,
Yep.
well, call it a revocation hearing, and we'll notice it, and
They've been very consistent for the past 2+ weeks, and they know we're watching, and if they lapse in their behavior, then I will not hesitate to.
well, I'm sure they're watching tonight, so you be careful out there,
So maybe in 2 more weeks, we can send him a gold star.
right?
I don't think
Or
they're
we
ever
re-
gonna deserve
or
a
we
gold star,
revoke it.
but
Smiley face at least.
Well,
that's me,
okay.
I'm done, thank you.
And any liaison reports this evening? LRPC?
Waiting all
Stacy?
night.
Sure you have.
So, what I have to say could take up an hour. I will
It
try.
won't.
No.
I'm gonna try and minimize to less than 5 minutes. So, I did go to
Thank
the
you for your report.
Lakes Region Planning Commission.
Come on, seriously,
The-
she's the only one, does all her homework.
It's okay.
Come on, there's always that one student.
The housing needs assessment has come out. It is online. I could just give you the highlights, though. Just a quick reminder, it addresses current housing needs, analysis of historic trends, existing conditions, and projection of future needs. Something that they added this year is an analysis of affordable housing needs. So that's on there. It helps us determine our compliance with RSA 674-58, that's the New Hampshire Workforce Housing Statute. We all must provide reasonable and realistic opportunities for the development of workhouse housing inventory. What is new this year? Municipal levels for need of affordable units. It used to be Lakes Region as a whole. Now Laconia had its own little spot. I knew you'd want to know. So our growth rate went up, but our rate is still lower from 2000 to 2010. So it did go up 5,533 people.
It's a lot.
Any questions on anything that you guys want to know about housing needs assessment? Because I'll move on to conservation.
Did they say how many units we needed?
Yes. So,
And what type?
darn it,
Not to prolong this, but
sorry, I've got it.
Despite your best efforts.
despite my best, yeah.
You know,
absolutely.
Make
New
something-
housing units, 1,180, and owners, 790. Renters, 390.
That's for the year 2040.
Going, that's a projection for 2040. Dean did have me go and ask why the state school property was not included, and the guy felt that he had included it, but I said, how, if you did, he goes, oh yeah, so your housing units projection will be fulfilled by that, and I said, but you're not taking into account the population change. And that's when he said, oh, you're right, and he wrote that down.
Did he forecast out how many approved units of housing we have currently?
5,000 is a big, wow.
I have that.
Listen, email her.
Sorry.
It is online now.
I'll retract my question.
Yeah, it is online. Housing units per acre,
I got you. pulled that right
Laconia.
up. See that? She picked the right.
It's highlighted too.
It's much more important to figure out what issues are in Ossipee, because there's so many people in Ossipee. And it is to figure out what the issues are in Laconia, don't you know?
I
Clearly.
believe Ossipee did leave the LRPC. So,
Very
however,
valuable.
that is online. And if I could move on to conservation, though.
Please do.
Please.
The state is no longer doing prime wetlands, so that's no longer an option. And our city ordinance goes by wetland size. And I attended a whole bunch of webinars on wetlands, and conservation was thrilled to hear that we really should talk to city council. I did want to talk to this board first on how you guys felt. Instead of going by the size of a wetland, you could have a puddle outside your home or across the street. If it is not big enough, the city will not recognize that as a wetland. But if it is recognized as something functional and valuable and prevents flooding your entire street, even though it's the size of a puddle, it should not be filled in and developed on. So, my question for the board to think about is, how do you feel about approaching the city council and changing that ordinance back to functions and values of a wetland instead of size? And you can take a month to think about that.
Makes sense.
Does the city have a certified wetland scientist on board, on staff?
No. We have attempted to do that on 2 different occasions with past staff members. We train them, and they leave.
So, Stacy, first of all, thank you for being the person that does all this homework, and I would.
I enjoyed it.
Well, I know you do, but if next time, instead of writing it into a little notebook, you were to email it to us in advance of the meeting, we could have a better discussion and get more information.
I
Because
actually
you
did
know
not
how
think
mu-
that was allowed.
You can email it to staff and they
You
can
can
email it.
you can email reports for which you are the liaison to this board, as long as we all receive it. So it doesn't violate any law whatsoever.
Oh, okay, I understood that to be any email, that there could not be any.
As
Just
long
don't
as there's
reply.
no discussion amongst us,
Don't reply.
don't reply.
Send it,
That's
send it,
really
put it
that
in the
simple.
BCC block.
BCC works
Just
really
call it,
well.
just call it liaison report for LRPC, liaison report conservation, liaison report city council. And then if there's any additional information, because you go through all of this, and then we stand here and tap our watch and tell us that you got 5 minutes. So that's my suggestion. Thank you for doing this.
I will take it.
But send it to us in writing in advance of the meeting, and you guys all know, you don't wanna create a quorum out there in Cyberland. So, just.
Oh, so then I could take this time to just answer questions instead of.
Exactly.
Got you, that sounds great.
Does
Well,
that-
does everybody read their email?
Sometimes.
Depends on who it's from.
Well, don't forget, I got a new one, so.
I'd have to take the block off you, but I think, I think we could do that.
Check my spam folder.
Yeah.
Okay, so that's Conservation and LRPC. City Council?
Nothing.
Nothing? Okay,
Or discussed it all.
how about the Historic?
We are still waiting for the city council to do something, and have you got something on that?
joint meeting with the Heritage Commission on the 12th, next week.
The joint meeting with who?
You with
Heritage Commission.
Okay, I'm more concerned about the city council acting on what we gave them
It
to
is
act on.
before the ordinance committee, and
I
we're
did
working
ask
it.
for that to be brought to them.
So is there a meeting been scheduled?
I believe it has.
There is one scheduled, I'm not sure if that's on the agenda, but I can double check.
If you get a date for that, you know, I'd love to know when that
Yep.
is, so. That's great, because then we can move on and we'll have reports. Have meetings.
Speaking of emails, I think it might be a good idea, if it's not that much more work for you guys, if you could CC the board members when the TRC meets or anything, so we can get you can do that? What?
There is a thing on the website, under planning, that I've got active applications, what's going to planning board, what's going to TRC, when they're coming back. It's been on there for about a year.
Oh, okay. So it's there for us to look at if we want. Oh, okay, good. Problem solved. All right, is there any other business? Sensing none. Well, Charlie, would you like to make a motion?
Yes, I'd love to make a motion to adjourn.
Is there a second?
Second.
Motion made and seconded. Any discussion? All those in favor? Good night.